My name is John Bodner, and I'm representing the Institute for Advanced Study. And tonight's presentation is part of our Branign lecture series. The Branign series is a series that brings distinguished artists and scholars, actually from all over the world here. And they not only give these formal lectures, but any of you who are familiar with the program know that someone like Jeremy Horder has been all over the campus this week, speaking to students, speaking in seminars, speaking to various centers and groups, and has more of that as well. So the lecture is a sort of a formality, but it's only one part of a busy agenda and a sort of a wide set of contributions to the Bloomington campus. The Branign lecture series and the Institute for Advanced Study is interested primarily in collaborative research and interdisciplinarity, and Jeremy Horder certainly fits that sort of mission of the Institute. You can tell in this particular case by the letters that nominated him for his appearance here and his trip to Bloomington. They came from the law school, they came from philosophy, they came from religious studies, they came from psychology, and so clearly he's already made an impact on scholars and thinkers in a great many fields. He is professor of criminal law at Worcester College, University of Oxford University. And he's currently the law commissioner for England and Wales, and that's a public service responsibility that he's taken up for 5 years, and then one more year he returns to his academic pursuits at Oxford. He has a long list of publications, most of which you're probably familiar with, including a book, Provocation and Responsibility, published by Oxford University Press in 1992. And I alert you to his forthcoming book, Politics, Homicide and the Politics of Law Reform, also imminent from Oxford University. So I give you tonight Professor Jeremy Horder.
Well, thank you, John, and it really is a great honor to have been invited to deliver this Branign lecture. I'm extremely grateful to you, and I would like to thank the Institute for Advanced Legal Study, John himself, and also Marcia for organizing this and for getting the support that I needed to come here. I'm extremely grateful to you. And of course grateful to the law school for hosting this event, which I'm very much enjoying, as I am my stay here as a whole. It's been fantastic so far. The last time, in fact, as I've been saying to some people, the last time I, in fact, gave a public lecture in the US a while ago now, there was actually an important rival attraction to my own talk, which was that when I gave the talk at the University of Maryland, at that very time, Hillary Clinton and Barack Obama were slugging it out in the sports stadium to see who should be the next presidential candidate. So it took a great deal of dedication for the people to come along to that particular night to hear me lecture instead. I suspect maybe quite a lot of non-US citizens perhaps were coming along. But nonetheless, it's a pleasure to be here and to be giving this lecture. And my subject for the lecture is the relationship, really, between scholars and legislators and the public and their input into the process of law reform and in particular when we are dealing with areas such as the law of homicide, which touch many people, on which many people have very strong views. Who should be able to exercise the most or the most important or the significant influence in the process of law reform? That's an important question, I think, for any democratic state, and not just for England and Wales, where we are going through the process of reform of homicide at the moment. And I want to reflect in particular on the role, if I can, on the role played by consultation with the public. How should their input best be gained and put to good advantage in the process of reform of important and controversial areas like this? On the other side, how much influence or sway should be exercised by scholars and other experts? Or should it all be just left to the legislators to get on with in their usual way? How should we try to assess the worth or value of each of these bodies and or groups? And this is broadly the outline of what of the path I want to follow in the course of the lecture. I'm going to be looking a little bit at the specific piece of legislation that we're dealing with, the homicide reforms, and the government's response to recommendations for reform, and then branch out a little bit more broadly into the questions I've just mentioned about the role of experts and the public. But let me start with what is an unusual institution for American lawyers, and that is the Law Commission for England and Wales. Now, the Law Commission, as the name implies, Law Commission for England and Wales, we only deal with that jurisdiction, not with Scotland and Northern Ireland. But law commissions are very widespread throughout the world. There are something like 60 throughout the world, something like that. The most recent being Northern Cyprus and Northern Ireland. And law commissions, although they vary a little bit in their nature, they are normally independent bodies, albeit paid for by government. And what they do is they provide an expert perspective on law reform. They make recommendations to government, and then government relies on the recommendations to make legal changes. So they are a formal standing body of experts which provide the impetus for law reform. And you can see here we have a very broad-ranging remit to take and keep under review all the law with which the law commissioners are concerned, with a view to its systematic development and reform, and the codification of the law and its simplification and modernisation. So a very ambitious task which government has set us, and the English Law Commission's been working away at this task since 1965. Now, it's probably true to say that most countries that have law commissions are in or are either current or former members of the British Commonwealth. You don't tend to find them in the US, for example, or in France or Germany. Continental countries don't have them. So they are a specialised kind of body conducting law reform. And although they're not a new idea, in fact one was suggested for 5th century Athens, I think, although it was never acted on. But the Law Commission struggles to keep up with its remit, to take and keep under review all the law, not least because of the huge increases in the size of the statute book over the years. So there is a tendency to focus on particular areas of controversy or interest to government, and in particular on reform of the common law, where there's a particular worry that the common law is inaccessible to the public, controlled solely by the judiciary, who can change it without reference to the democratic process. Most US states who have codes have eliminated the common law, although there still are, of course, those that rely very much on its doctrines. Now, how does the Law Commission approach its law reform projects? Well, the Commission can, because it's independent, pick up and look at issues of its own motion. It can decide to look into something independent of government. Or the government of the day may decide to ask the Commission to look into something when, for example, it's not sure what the answer is and it requires a longer look or a more expert look, and so it turns to the Law Commission to do that. And the Law Commission's report on murder, which was published in 2006, was a project of that kind given to the government given to the Commission by the government in 2005. Now, how does the Commission go about its work? Well, ultimately it writes reports with recommendations for change, and also attached to those reports will be a draft bill, and we'll look a little bit at one of those in a moment. In other words, a bill that can be taken straight to Parliament and put through if necessary. But more important than, in my view, than the fact that the Law Commission reports and makes recommendations is the fact that, first and foremost, the Commission sees itself as a consultative body. That the very first thing that it does in the process of law reform is to draft a consultation paper or document, and that contains an analysis of the existing law, its defects, and then it has provisional proposals and questions for consultees about what should happen next, or what should be, or what is desirable as a reform. And that document is then circulated very widely, not just to the legal profession, but to all interest groups, members of Parliament and others who could possibly have an interest in this area. It's also published on the website so that more generally members of the public can respond if they're so minded, and in fact they do respond in quite large numbers on the very controversial issues to our consultation papers. Then there's a consultation period of a number of months, during which, as Commissioner, I will, for example, as I did with murder, travel around the country, meeting judges, experts and special interest groups to publicise our proposals and ask for their responses, gathering as much feedback as I possibly can. In the case of murder, we also commissioned, which was an unprecedented step for us, but we also commissioned a public opinion survey expert to conduct some research taken from a cross-section of the public and that cross-section was to include at least one close relative of the victim of a murder. And the question we wanted to know was how wide-ranging the defence of provocation to murder should be. And I'm going to come on to talk about that in a moment. And the survey came back with the answer that if provocation is serious enough, grave enough, the public, this cross-section of the public that we surveyed, believes that it should be a sufficient ground for reducing murder to manslaughter, even if the provocation did not take the form of a threat of the use of force or violence of some kind. And because that was the government's preferred stance, and as a result of our having commissioned this public opinion survey, the government actually changed its mind and retained, at least in some measure, the broader provocation defence. And that's an important point in the context of this lecture, really, about the influence that properly measured public opinion can have on the legislature. But to give you some idea of the sorts of bodies that we consult, here are a number of the bodies which we consulted in the course of the Homicide project. Opposition political parties are consulted, the senior judiciary, obviously, as well as lower levels of the judiciary, police organisations, including specialist firearms units and so on, who may be influenced by changes in the law of homicide, and more broadly what you might call interest groups, those who represent victims, those who represent women's interests, and Dignity in Dying, those who are in favour of limited forms of euthanasia, and indeed, of course, those who are totally against it. I haven't listed there, but we also would have consulted them. So we try to consult a wide range of interest groups, and it's important to note at this stage that our proposals on provocation as a defence to murder were widely supported as between these groups. Although they might not necessarily have much in common between themselves, they were in broad terms behind our proposals on provocation, which is an important matter to mention just for now. Now, having consulted, got all our consultation responses in, we then write our report in the light of those. We're not bound to reflect exactly what consultees want, but broadly speaking, that will be the path that we choose. And when they've received our report, government then takes time to consider, obviously, to decide what the next steps will be. Government may then conduct some of its own consultation, that's possible, but normally they will simply rely on the consultation that we have done. And then a certain amount of time later, they have a certain period of months before which they are bound to respond and to say what they're going to do, and they will either endorse, reject, or defer our recommendations, depending on what they think of them. Now, that then turns me to what we actually recommended and what the government decided to do about it, which I think is worth spending a little bit of time on, because it is of some interest. I mean, I won't go through it all, because some of it's quite complicated, and you're not here to be taught about the English law of homicide, so I won't go into it in that much detail. In broad terms, the reforms that we recommended would make the law look a little bit more like that which is familiar to those in US state jurisdictions. So at the moment we only have murder and manslaughter, and they will become first-degree murder, second-degree murder and manslaughter. So that you'll be very familiar with that structure. More importantly, perhaps in this context, provocation and diminished responsibility as defences, diminished responsibility being a mental disorder-based defence, instead of reducing murder to manslaughter, as under the I get to use this thing now, as under the current law, they would reduce first-degree murder to second-degree murder instead. And that was very strongly supported by victims' family groups who wanted instances where there had been an intentional killing, but nonetheless in mitigating circumstances, like provocation or mental disorder. They wanted that to be reflected in a murder verdict, basically, and what we were offering them was second-degree murder, and they were happy with that. So that was a an important feature of our consultation. I won't spend much time on this, but first-degree murder was going to include, obviously, killing intentionally. Every state that you look at across the world has that in there somewhere. But also a lesser but quite closely allied form of intent, namely killing where there was an intention to do serious injury and also an awareness that there's a risk of causing death. Now, that's a bit of a cumbersome formula, but what that's meant to encompass is the classic case where someone is kicked in the head or maybe stabbed in the stomach or something of that kind, and they say, oh, well, I didn't actually intend to kill, but nonetheless they can still be convicted of first-degree murder if there was an intention to do serious injury, which clearly there would be, I think, in the case of stabbing in the stomach or stamping on the head. And the question is whether the jury will infer that there was this extra awareness of a risk of causing death. So that would narrow slightly, but not very much, the current law of murder, because the current law of murder is killing intentionally or killing where there was an intention to do serious injury, full stop. So it would slightly narrow the scope of murder as it is. And one of the things government asked us to do was actually to go through a whole year's worth of homicide or murder cases to see how many we thought would actually still fall within this category. And the answer actually is probably most of them. So there wouldn't have been much practical change. About 80% of cases would still fall within that. Now, second-degree murder is the kind of interesting one, the one that's really doing the work under our reform proposals. Here, you fall into that category as in terms of offence, where you intended to do serious injury, but without the awareness of a risk of causing death. And that's quite a common kind of case, in fact. So it includes cases where people deliberately run over someone's leg or something like that, and they then get a thrombosis or something and die. That could now be second-degree murder under our proposals. The second category is a bit more of a complicated one, where there was an intention to do some injury or create a fear of a risk of injury and an awareness of a serious risk of causing death. Now, you might wonder what that's all about, but the classic case of that would be where someone sets fire to a house, giving the occupants perhaps some opportunity to escape, but in the fact they don't escape and they're killed. And in those instances, we thought that's sufficiently serious to be second-degree murder, but it probably only involves actually an intention to create a risk of injury, although there is an awareness of a risk of killing. So that's a slightly complex one, but one that nonetheless we felt ought to fall within the scope of second-degree murder. That's probably, in a way, it's the closest we come to having a version of felony murder, I guess. But obviously it's not like felony murder because you're not guilty of it just because you happen to kill in the course of an unlawful act. There's a lot more to it than that by way of fault element. And finally, within second-degree murder, as I've already said, the effect of a partial defence, a successful partial defence, would reduce first-degree murder to second-degree murder. So provocation and diminished responsibility in particular. Now, I won't bother going through the manslaughter, which is not, I think, of particular interest. It's broadly the same as it is now, gross negligence killing. Now, the real issues here are, although I've gone over those quite quickly, and you might wonder why, and the answer is that the government got rather cold feet at the prospect of changing the law of murder to that radical extent as they saw it, and so they have deferred for the present time consideration of changing the structure of the law of murder so that we have first and second degree. They've deferred that to a later date, so I've no idea when that's going to come back. But what they have done, and it's now going through Parliament at the present time, what they have done is taken some action on the partial defences, provocation and diminished responsibility. These are governed by an old piece of legislation of the 1950s, which is now beginning to show its age. The provocation, as I've already said, has two possible bits to it. One is where there's a fatal reaction to a fear of serious violence. So essentially you've overreacted to a fear of serious violence, so you can't plead self-defense itself and be acquitted, but what you can do is reduce murder to manslaughter. And that was put in there. There's no real equivalent to that in English law at the moment. And that was put in there very largely to satisfy the concerns, in particular of women's groups who were saying that very often when women respond to, or when they kill, particularly in cases where they kill their partners, normally the motivation is fear of serious violence because the partner will be an abuser and will have abused them over a period of time, and that is why they respond in this way. And the current law makes no provision for that, actually. The current law is reliant wholly on the notion of provoked anger. And provoked anger is not normally the reaction of a battered woman in these situations. So the law, it was thought, was operating unfairly, actually, against battered women who kill. And for that reason, the provocation defence needed to be broadened. And that was a very popular suggestion amongst consultees. We recommended it. The government has now adopted it. The other thing that they did, and that concerns... wrong way. Trying to be too clever with my pointer. Now, these bits here, down the bottom, that's the modified version of provocation at large, more generally. The bit that the public in our survey said that they wanted to keep, but the government wanted to make sure it was very narrow. And as you can see, there are quite a lot of hurdles that have to be surmounted. It's not an easy defence to succeed in. You have to show that the reaction was to gross or very grave provocation of a kind that gives rise to a justifiable sense of having been seriously wronged. So not just any provocation will do. Moreover, the judge is to be given a power to withdraw the issue from the jury. Now, what we recommended was also that we should abandon the loss of self-control requirement, because that was causing problems when, in the battered women situation, where there wasn't actually really a loss of self-control as such, although there was a reaction motivated by fear of the abuser. But the loss of self-control requirement was getting in the way of women being able successfully to plead this defence. So we recommended that that requirement should disappear. Now, on diminished responsibility, I won't dwell on this, and particularly not on the definition, but one interesting point here, which was rejected by the government, we suggested that, where is it? Yeah. One ground for pleading diminished responsibility should be developmental immaturity. That is, that the offender was, in a way, educationally not as advanced as someone would normally be for his or her age, and that should be a ground on which, if they killed somebody, it could be reduced from first to second degree murder to give the judge more discretion over sentencing than would be the case if there was a conviction for first degree murder, where, as at present, the judge would have to pass a mandatory life sentence. But the government thought that was too generous to the accused, and they've deleted that particular ground for reducing murder to manslaughter. So, I mean, this was a little bit like, we spent a lot of time looking at Roper and Simmons and the decision of the Supreme Court in that case, where they were talking about the difficulty, for those of you who've read that decision, the difficulty of distinguishing between developmental immaturity and mental disorder of some kind. Psychiatrists sometimes have difficulty distinguishing those two things in a very young defendant, and we were concerned about that and wanted to try and make some provision for the difficulty. But the government did not accept that. Now, so those were our recommendations. The government has changed them around a little bit, and in some respects in some important regards. Now, here is the government response on provocation, other than in cases of fear of serious violence, because that is that one they have accepted already. Now, what they've done is reinstated the loss of self-control requirement. They wanted to hang on to that requirement as a way of narrowing the scope of provocation. They've hung on to that. And what they say is that the provocation must be such that a person of the defendant's sex and age with a normal degree of tolerance and self-restraint and in the circumstances of the defendant might have reacted in the same or in a similar way. So, and that's very similar to what the current law requires. But the interesting point, I think, is that it says the loss of self-control must have had what they call a qualifying trigger. And here it is. The provocation must have been in circumstances of an extremely grave character, must have caused the defendant to have a justifiable sense of being seriously wronged. That's very much the language that we were using in our report. So far, they follow pretty much what we suggested. Now, in relation to those conditions for reduction from murder to manslaughter, there are certain things that are to be taken into account and disregarded. For example, here, the loss of self-control, the qualifying trigger is to be disregarded if it was incited by the defendant himself. Well, that's pretty obvious. That's an old rule. Most importantly, though, the government added a new category of thing to be disregarded. Here, the fact that a thing was said or done constituted sexual infidelity is to be disregarded. Now, that was not something specifically that we had considered, because we thought that pure or mere sexual infidelity would not succeed before a jury, because they would take the view that it was something that would not give someone a justifiable sense of being seriously wronged, such that any ordinary person might have reacted in the same way. I mean, it didn't seem to us very likely that a jury would accept that. But the government wasn't sufficiently confident about that, and so they stuck in a specific legislative provision to ensure that something said or done constituting sexual infidelity is to be disregarded. Now, that produced quite a split, actually, between groups who supported this, interest groups who thought that the law should be tougher, particularly on men who respond to sexual infidelity with violence, and one could see the argument there. But lawyers were concerned about the rather arbitrary scope of it, I guess. For example, even the drafting of it seems a bit odd. Can something said or done actually, or can something said constitute sexual infidelity? I mean, that seems a rather strange notion. Perhaps you can send me some answers on a postcard, but it seems a rather odd notion. I think the other point about it, which I mentioned earlier today to some of the students, is that the notion of sexual infidelity is a rather quaint one in a way, because of course there are only duties of fidelity within marriage as such. If people are living together, they're not in law regarded as having any duty of fidelity. So it'll be an interesting question for the courts, I think, whether they'll be willing to extend this exclusion to cases where two people have been living together and one has is discovered having an affair with another person. It'll be interesting to see whether the courts extend it that far. Anyway, so that's a kind of interesting extra point. I mean, we weren't terribly in favour of it at the Commission because we thought it would just generate far too much case law and toing and froing up in the appeal courts over what these words mean. But nonetheless, there it is. It's not wrong, I think, as I'm going to say towards the end, that sometimes legislation has this has elements in it that involve concessions to certain groups who are influential. That may not be wrong in all instances. Okay, now, where have we got to? Oh yeah, I don't want to get onto that bit yet. Now, so that's where we are at the legislative stage at the moment in relation to our proposals. Now, what I want to do, I think, is to go on and look at a number of ways, try to analyse this as a process of law reform. Is it a satisfactory way of going about law reform? That's the question that I really I want to focus on. Now, there's a number of different ways in which you can allow law reform or you can promote law reform. One is, of course, just to leave it to the legislature, to the elected members of your legislature to get on with. And not allow anyone else to, and just say to themselves, well, look, they're the elected representatives, let them get on with deciding what laws should govern us. And that, of course, has a certain appeal in a democratic state. We can see the advantage of that. But it also comes in for a lot of criticism as a way of conducting law reform, because it is said that legislators act purely on gut reaction. They don't think proposals through. They engage in what one criminal law theorist, United States theorist called Paul Robinson, has said mere politicking is what they engage in when they conduct law reform, as opposed to what he calls deliberate craftsmanship, which is a rather nice idea. And In fact, this image of how the legislature behaves in conducting law reform was rather nicely captured 200 years ago by the law reformer Jeremy Bentham, when he said, in criticising the way that the legislature or legislative reform comes about, he says, or in the criminal law, he said, the country squire, he says, has his turnips stolen one summer. So he goes to Parliament to get a bloodthirsty law against stealing turnips. It exceeds the utmost stretch of his imagination to realise that the same fate next summer may happen to his carrots. And from that we learn this lesson, says Bentham, that the two modern rules of legislation are that you never act until your passions have been inflamed, and when they are, you never look further than the end of your nose. And it seems to me that that is very much the criticism that can be made of legislators now, just as it was in Bentham's time, 200 years ago. That may be an answer. That may be an argument in favour of improving legislative processes, making those processes more amenable to other kinds of influence. That's perfectly possible. But that is people's worry about using the legislative process. Now, there's an alternative, which is what I'm going to rather meanly call the elite viewpoint on the law. And the elite viewpoint takes a very low view of the influence of legislators, or indeed anyone else, in the process of law reform. And here we have, as an older view, we have Sir James Stephen, who devised codes, criminal codes, which were put into effect in Australia, New Zealand, and indeed in other countries at the end of the 19th century. And what he says about the legislature is that Parliament is an ass made up of clever fellows who empty their talents in ignoble squabbles and successful attempts to fall to the level of their constituencies, which they properly despise, he says. So that's what he thought about the Parliament's role in this whole business. And that really is not untypical, I think, of some law reformers who devise codes. They have quite a large measure of contempt for the legislature. Well, what about scholars? Where do they fit into this picture? Well, they don't, I think, quite take an elite viewpoint, because they don't straddle the political and scholarly divide in the way that some judges or other influential people do. So I wouldn't quite want to call theirs an elite viewpoint. But the scholar, as law reformer, it seems to me, commonly believes that their, what you might call their isolationist scholarly methods, sitting in their rooms, dreaming up ever more refined versions of criminal codes, that is ideally suited to creating the right kind of law reform. And here we've got a quote from John Austin, well-known professor of criminal law in the 19th century and law reformer. And what he said is that if they give me £200 a year, he said, for 2 years, I would shut myself in a garret, and at the end of that time, I would produce a complete map of the whole field of crime and a draft of a criminal code. And that's the famous Austin who wrote The Province of Jurisprudence Determined, which students of Hart will know all about, or a fair bit about. And that's really a not untypical reflection of the way in which scholars regard their role in relation to law reform. It rather has echoes of what Paul Robinson called the notion of deliberate craftsmanship rather than mere politicking. The idea that one must shut oneself away from other influences and carefully craft a criminal code, which one then reveals to an expectant audience and has implemented by a very grateful legislature. That is not an uncommon view. And indeed, for example, the views of scholars become a kind of reference point, really, for the moral principles that should infuse legislation. So Professor Husak has said, for example, from Rutgers, he says, virtually all commentators, he says, attach enormous significance to the requirements of fault in legislation. And so statutes that don't have requirements of fault, he says, should be regarded as normatively suspect and placed on the periphery. And in that way, he is trying to bring the scholarly perspective to the centre in moral terms. Now, That, I think, is quite a problematic way of privileging an expert perspective, because it seems to me that in terms of legitimacy, just one or two or a group of scholars hiding themselves away in Austin's garret and coming up with a set of law reforms is not likely to have the kind of democratic legitimacy that a law reform proposal should have. And scholars have a number of ways of trying to meet that point. One quite commonly used method is to say that what they're putting forward is just common sense, really, or any rational person would agree with what they are saying. So there's no need, really, to go and consult anybody, the public or anyone else, because this is just plain common sense or absolutely obvious. And an example of that is one particular theorist in Cambridge who says, can it really be doubted, he says, in England and Wales, that it's lawful to do whatever is known to be necessary and is in all the circumstances reasonable to avoid any injury or pain or suffering, or to discipline a child in one's care, he says. And if it cannot reasonably be doubted that those things are right, ought these eminently rational propositions not find a place in any codification of general defences, he says. Now, I myself don't believe that that kind of justification for principles that one has oneself developed in one's Cambridge College is really a model for law reform. You cannot appeal simply to the rationality or supposedly common sense basis of your proposals. Must everyone rationally accept, I wonder, whether you can use force or confinement to discipline a child in one's care? I mean, is that actually something that's obvious and rational? Well, there are many organisations who campaign against the use of force to discipline children and would like to outlaw it completely. So I don't really see that as meeting the test of something that any rational person would regard as acceptable. Similarly, he says in that quote there that it should not be criminal to do whatever is believed to be necessary to avoid injury. Well, one might wonder, for example, about the actions of the armed police officers who shot dead the Brazilian John Charles de Menezes on the London Underground. No doubt they believed that what they were doing was proportionate and reasonable in the circumstances, but that's hardly an uncontroversial judgment to have made. So I don't think that these appeals, if you like, to inherent rationality or common sense will necessarily do the work that, or enable you legitimately to bypass some kind of consultative process and rely solely on your scholarly learning, as it were. Another strategy that's sometimes adopted by scholars to privilege their own position is to say, well, the public in particular, they're only moved by emotion. They're not really moved by rational considerations. So we don't really have to pay much attention to them. A well-known expert on evidence, for example, Professor Roberts, was talking about that is the Law Commission's proposals, which are now law, to get rid of the double jeopardy rule, which is, of course, in the United States an important constitutional provision, but it's now been abolished in the United Kingdom. And he was talking about the influence of victims of crime in getting that piece of legislation passed. And he says, for the purpose of designing and implementing a system of criminal justice, it's best that the opinions of those stricken by fear or grief should defer to the deliberations of more sober and reflective citizens, he says, presumably like himself, I would imagine, who can take proper account of the experience of victimization alongside the full range of other pertinent considerations. Any narrower or more truncated response, he says, soon exhausts itself in ignorance, prejudice, or dogmatic assertion. Now, again, I wonder really whether it's very fair or right to contrast the position of the scholar or expert as the sober and reflective citizen and the member of the public as merely someone who acts out of ignorance, prejudice, or dogmatic assertion. I mean, I find that rather hard to accept, I have to say. I don't believe it's true at all. And that you can't just dismiss the attitudes of victims' families and so on in that way. I don't think that's right at all. Now, let's try to let me try then to begin to suggest how one might try to meet this issue of the high scholarly standards that scholars set themselves in making reform proposals and the attitudes of the public. What can we do to try and understand the input that each has? Well, what I'm going to do is just distinguish for you different kinds of reasoning that may be brought to bear on the reform process. Now, first of all, we've got, or what we can call, single issue reasoning. And secondly, there is also what one can call reasoning from a point of view. Single issue reasoning and reasoning from a point of view. And those kinds of reasoning can be contrasted with the form of reasoning generally adopted or presumed by scholars, which is what we can call general principle reasoning. And that's the reasoning commonly employed at common law and also by scholars in law reform. I think that all of those kinds of reasoning actually can have a legitimate claim to influence over the criminal justice process. And let me just say a little bit more about that. Now, scholars tend to prefer general principle type of reasoning because what they want to do is to avoid particularism, as you might call it. They want to involve special classes of case being picked out for special treatment without being set into a general context. And if you recall, here is an example of particularism to which the general principle reasoner will make objection. This kind of special provision, picking out something without setting into a more general context. The general principle reasoner is going to object to that because that's going to look like either a single issue kind of reasoning that you're worried about that as a ground of provocation, or it might only reflect a point of view kind of reasoning. That is, for example, a women's interest group point of view. It may only reflect that. And the general principle reasoner is going to object to it on those grounds, I believe. And that's going to be why they don't like that. I could say more a little bit about that, but let's just try and examine these other kinds of reasoning that are not the general principle kind. Now, reasoning from a point of view is actually often employed in some respects by scholars themselves. So you might, for example, get a socio-legal examination of a particular problem, or you might have a perspective that looks only at the impact of a reform program on particular sectors of the population, ethnic minorities, younger people, whoever it may be. And in one sense, that's reasoning from a point of view that's very familiar even to scholars. But as a programmatic kind of reasoning, we're most likely to find it employed by special interest groups of various kinds. And it's interesting, I think, to note that a lot of the bodies that I said that we consulted are going to be having an input into the reform process by reasoning from a point of view, if you like. They all have their own particular point of view or their line of argument that they want to push, if I could put it that way. And some of them will be single issue people, and Dignity in Dying, I guess, would be an example of that. They're only really interested in what we've got to say about, if anything, about euthanasia, not about anything else. So they are single issue reasoners. I mean, it's not wrong for that reason. There's nothing wrong with being a single issue reasoner, but it's different from the way in which other bodies will try to influence the process of reform. And I've already mentioned one respect in which the victims groups turned out to be a bit of a single issue reasoner, because what they wanted was to ensure that diminished responsibility and provocation reduced first degree to second degree murder, not down to manslaughter. That's the thing on which they pinned all their efforts, really. So a single issue kind of approach. Now, single issue reasoning does, I think, have some logical force to it. It's not an illogical way to approach law reform. And in particular, of course, it's not, I think, as Professor Roberts would suggest, pure emotion or prejudice or something like that. It might be, but it's not necessarily going to be that. There may be a perfectly perfectly logical or indeed moral force behind the single issue that you are concerned with. But what distinguishes it single issue reasoning from point of view is that it may be the discernible result of a public opinion survey or something. That may come out of that what most concerned people is this single issue. For example, there was a radio survey on what people thought was the most important issue for the criminal law in Britain, and because of various things that had been going on at that time, they all said, we want the householder to have greater rights to resist burglars who are entering the premises. So we want greater powers to take action against them. So you sometimes get single issue emerging in that way from public opinion surveys. But single issue is different from point of view reasoning because it's not the product of predefined and an articulated kind of perspective, if you like, in the way that the social science researcher will be. And I've already mentioned that some of the reforms that have been proposed for provocation are clearly the product of single issue or reasoning from a point of view perspectives. Although, even so, I think the general principle reasoner, as I said, is going to be suspicious about that kind of influence. Surely the general principle reasoner will say single issue reasoning from a point of view are inevitably partial kinds of influence on the law reform process. Perhaps even they embody a distorted vision of justice, it might be said. And that brings me back in a way to the law reform process and how we should realign it to take account of these different kinds of reasoning. And if we come back to the work of the Law Commission, I think what we can say about that is that in general terms, the Commission's processes are dominated by general principle forms of reasoning on which scholars and legal professions have a very considerable influence. However, in our consultative processes that I've described to you, a distinctive feature of those is that we are open to groups and organisations who reason from a point of view or from on a single issue basis. So in that sense, we're very different to scholars who are not, in general, of course, consultative in the way that they formulate their views. That's not the way that they generally proceed. So in that sense, I would say that the Law Commission has an advantage in terms of legitimacy over a scholar or group of scholars who might think that they can do better. However, there are problems, I believe, in terms of legitimacy with the way that law commissions, including the English Law Commission, do their work. And that is that consulting with these groups that I've listed here is mistaken for genuine public consultation, genuinely finding out what the public thinks and believes, which I think ought to be part of a genuinely participatory kind of democratic approach to law reform. Now, public law theorists, I think, are likely to say that the kind of consultation that we do in this way, rounding up all these usual suspects, as you might call them, these groups for consultation, that has a kind of pluralistic interest group basis, and it must confront the problems of interest group pluralism, which are, of course, that these groups may not represent the views of the public, even on the very issues with which they are concerned, that they may not actually be in touch with true or genuine public opinion. We simply don't know, to a very great degree, whether victims of crime groups, victims' family groups, actually represent the views of the public at large on these issues. And I think that's a problem. Another problem with interest group pluralism is, of course, that a lot of these groups will actually be used to facing off against one another, both in the media and elsewhere, and that can lead sometimes to a kind of adversarial process in which, when they are making their recommendations to us, they are also in part anticipating objections that they know are coming from some rival group who we will also be consulting. And that can also, I think, distort the consultative process in a way. And I think there is a tendency, one does see this, for governments and law commissions, ourselves included, to take a rather complacent view that as long as they've completed the tick box exercise, they've consulted all the usual suspects and then come up with a view, well then that's enough, really. And it's interesting, I think, that when the government was defending its view that sexual infidelity should be ruled out as a ground of provocation, what they did was appeal to a list of groups who supported it. They said, oh, well, look, it was supported by these organisations, and then they said that. But what they didn't say really was, well, but why didn't these other groups who might easily have had an input support it? I mean, or did they have anything to say about it? So the appeal to interest groups, I think, can be a dangerous one in terms of legitimacy. Now, but I think there are now, and I want to conclude by saying that I think there are now much better opportunities than before than to escape this rather narrow interest group plural approach, which can turn out to be a rather combative and slightly complacent way of developing law reform proposals. Now, it's stating the obvious to say that with the benefit of the internet, we have much better means of communication and collaboration with quite literally millions of individuals that we didn't have before. And in fact, at the Commission, we have tried to use these by having online consultations. But I think what's also now happening, both here and in the UK, is that properly researched public opinion surveys are being used now to actually gauge public opinion on certain issues. Public opinion surveys were originally confined to uses as marketing tools, really, to find out what people wanted in terms of goods and services, and also to collect demographic information for government about family patterns or residential patterns, whatever it might be. But they're now increasingly being used by scholars and also government officials as a way of finding out what cross-sections of the public actually think in response to certain structured questions, in order to counter media claims that the public is on their side in wanting to bring back hanging for this or that or whatever it may be. That it can actually be used as a genuine counter to that, because you have investigated public opinion properly. And I think the importance of this new way of using public opinion surveys is that they do provide scholars with a unique opportunity to test their favoured conceptual structures at the bar of public opinion, and to provide some kind of, if you like, public legitimacy as well as intellectual rigour to their own proposals. And that may, of course, involve them in some unaccustomed intellectual humility, because I think in order for that to be legitimate, they will have to be willing to ask difficult or controversial questions to which they might not want to hear the answer, like, should you have greater powers to resist burglars who come into your home? Should people who kill children automatically get higher sentences than other people, and so on? These difficult questions, I think, are there to be answered. It is possible to find out what the public really thinks about them. And I'll just give one example to finish up where I think an opportunity was missed to do this. As you know, in the law of murder in the United Kingdom, we don't have the death penalty, we just have the mandatory life penalty, and that involves serving a very substantial amount of time in prison, as you might expect. Now, but the question is how much time? And in 2003, the government issued, it just suddenly emerged as if from nowhere, a schedule to an act which set out what would be the starting point for judges in sentencing. And what they said was that someone should expect to serve their whole life in prison. That should be the starting point or assumption in cases of sexually sadistic murders or terrorist murders, or where more than one person has been deliberately killed in separate incidents. So serial killing, in other words. And that should be, the starting point should be whole life in prison for that. Then there should be a 30-year minimum as a starting point in cases where a firearm has been used, or the homicide was committed for the sake of gain, or the homicide was of a child. And then below that, 15 years in prison should be the starting point for other kinds of murder. Now, that we can argue over the merits and demerits of those figures and whether they're too crude and whether they include too much, too little. But what a golden opportunity was lost, it seems to me, there to conduct exactly the kind of public opinion research that would have given those categories some real public legitimacy, rather than making them look, as I'm afraid they have tended to look, as just the views of one rather unpopular Home Secretary at the time, whose legacy to the criminal justice system was this structure. It seems to me that a big opportunity was missed to do that. And I think the lesson I want to draw is that it is possible, actually, for scholars and others to come down from their elite platforms to consult genuinely on a proper basis with the public and to provide the legislature with some really, with legislative reform that has both principle and popular support. Thank you very much.
Yeah. Are we allowed to ask questions? Is it all right?
I hope so, yeah.
Great. So on this question about consulting the public, there seems to be a kind of a premise that maybe is unspoken.
Yeah.
I'm trying to figure out whether the purpose of that is limited to legitimacy, and it's a political purpose only, or whether it's because because you have a kind of soft spot for lay moral reasoning on the merits, in other words.
That's yeah.
And I don't mean to be pejorative.
No. Yes, I think the point would be that over the last 20 or 30 years, in a lot of fields or areas, not just the criminal law, public consultation before you do something has become an important element, both at local and national levels. Now, I don't know about here, but in the United Kingdom, we've become very cynical, actually, about public consultation. What we actually believe is that the decisions are taken already, and then, I don't know, just over a short period, a little notice goes out slipped out in the newspaper or something, just so that you can say you've done it. So that actually it has become rather perfunctory. It actually just constitutes money thrown away, really, because it's not truly engaging with people and with what they think. Now, so I'd actually want to leave open the possibility that the general public could come up with something genuinely new that you might not have thought of, and in that sense you're using their reasoning processes, as it were, to come up with a solution that and that's always possible, and those things have happened, although that's likely to be quite rare, I think. I think more what you're trying to do is to gauge legitimacy, in that what you're trying to do is compare a number of different possibilities and to say, well, to a cross-section of the public, well, which of these is more important to you? Or if you had to choose between this and that, which one would it be, if you like? So, I mean, the question I haven't really gone into, because it wouldn't have been appropriate here, is, well, how do you design a questionnaire that is meant to draw out these questions in an appropriate way? And at the moment, we're doing some public opinion survey on the not we, but some scholar colleagues are doing some public opinion survey on the mandatory life sentence, what they think about it. Now, one of my difficulties about the way that public opinion research is currently done is that the questions tend to have a slight bias towards what you might call broadly liberal answers. So the question is, well, look at these effects that the mandatory life sentence has. Do you really think it's such a good idea? Expecting to get the answer back, oh, well, if it has those consequences, well, then maybe it's not such a good idea. So I think what I was saying towards the end there is going to be quite important, that when we are gauging public opinion, we have to be reasonably brave. We have to be willing to get back answers that we don't really want to hear, essentially. And that's part of this process. But I think I don't think I'd want to split up the two influences that you're saying. I think that part of legitimacy is being open to these new or different forms of reasoning and being willing to sacrifice a little bit in terms of your nice general principled structures in order to show that actually the public can make a genuine difference. And of course, that the public will have to learn through its mistakes, that if things don't work, if it ends up with more people being acquitted than convicted, which was precisely the opposite of what you wanted, well, then you're just going to have to go back. But that rather messy style of government may be more legitimate than the one which, as it were, pre-packages everything and never actually dirties its hands with public consultation. Yeah.
I was wondering if you could actually say a little bit more about legitimacy, because if I'm following you, the concept has actually undergone some change as you've moved from the pluralist interest group model to the more broadly public interest group model. And this is a yes or no question, but it's also an invitation to say more. If I'm following you, it seems that in the earlier model, legitimacy was really attached to process. That it was by virtue of having some consultative method that the reform was conceived as legitimate. Whereas now, if I understand you, legitimacy is really anchored not to process, but to having secured a rather stable consensus, right? That the outcome, in fact, has a wider range of agreement than before, and that's what counts as legitimate. Is that right?
Well,
and
that's
if that
maybe
is right, that seems to me a very big difference.
Yeah, it would be, except I think it's actually, I'd actually want, I think going so far as to say you could create a consensus will probably be going a bit too far.
Not an absolute consensus, but that it has a greater measure of what seems to be empirically establishable or demonstrable consensus.
Indeed. I mean, just to go back to what you were saying before, I mean, part of the broader picture of the work I'm doing on law reform is to show how this process has developed from a period in the late 18th and early 19th centuries where really only the elite version of consultation, if you wanted to call it that, was taken. That is, only the judges really were regarded as competent to decide on what criminal law reform should be. And in England, that view persisted pretty much up into the 20th century, actually, that when law reform groups were gathered together to look at the criminal law, they didn't even include scholars. I mean, they were regarded as sort of not worthy of consultation, let alone any interest groups. And it was only during the middle years of the 20th century that it became accepted that you probably ought to ask police groups, one or two others maybe, who would have something to say. That process has accelerated, and now, of course, a very wide range of interest groups is consulted. But that, I think, has what's happened now, as I say, is that that process has stalled in terms of legitimacy for the reasons that I've mentioned. It's now, I believe, an almost moribund process of just box ticking, really, so as to check that you haven't left anyone out who ought to have been left out, really. It's a bit like inviting people to your wedding. You know, there's a whole load of people you don't really want to invite, but you know you've got to invite them for form's sake, and you know they'll say no, but, you know, at least you invited them. Well, that kind of approach, I think, is no longer fruitful, and I think law reform bodies are going to wake up to this over a period of time, over the next few years or so, I would hope.
Just as a footnote, it seems as you move beyond that impasse, just philosophically, the whole concept of the public seems to be undergoing a transformation.
Yeah. Well, I think that's right.
It's just the concept that the way it's conceived is radically different.
Sure. I mean, and there are different conceptions of it. I mean, the media has a very different understanding to that. Which, sure.
Just more generally, it seems like in our time there's, and maybe I don't know enough about this in the past, there's been more of a attention paid to victims as a voice in ways that maybe didn't pertain in an earlier period. And so basically two questions. I mean, is there a history here? Is there a point in time when you see the sort of idea that the victims or victims' relatives, etc., now seem to merit, in the general view, a greater voice in the discussions? And is that grounded more in, is that a manifestation of more public input, or is that something that comes from some elite-driven or some government body itself?
Well, the first thing to say is that the victims or victims' family groups in the UK are not as radical or as extreme as some groups in the US, I think it would be right to say. I mean, the groups in the UK, I mean, they have an agenda, of course, but it's not quite the... I mean, maybe these things get misreported in the UK, I don't know, but it doesn't appear to be quite as extreme as some groups here in the US. I mean, in the UK, there are specific aspects of the trial that they want changed so as to they get better information about what's going on. I mean, some of it's really quite mundane in some respects. It's not terribly ideological in many ways. But I think that when you do get down to brass tacks, as we say, and you say, well, what do you think should happen to people who commit murders or something? Well, then then you're going to get some quite dramatic views probably about what should happen to sentencing and so on. And I think what I'm suggesting is that these groups have enormous media impact because they are. There's a tendency in the media, and this is perfectly understandable. I'm not criticising. To want to, you've got maybe 2 minutes to do a news item on reform. So what do? You have a 10-second clip of the proposer saying what they want, and then you have 2 further 10-second clips of a victims' interest group saying, well, it doesn't go nearly far enough, and then some scholar in university saying, oh, well, it goes too far, or something of that kind. And then that's your news item. That's a wrap, as it were. I think what I'm suggesting really is that you can actually, to some extent, undercut the ground which they would seek to occupy by, and this has been done on a number of issues in relation to sentencing, by showing that if you ask certain kinds of question to members of the public about sentencing, so if you say, you don't say, well, should those who engage in unlawful child sex get heavier sentences? Because people always say, oh yes, much heavier sentences. They always say that. So what you do is you set them a problem. You say, okay, well now here we've got a 15-year-old boy and a 15-year-old girl, and you know they break into their parents' drinks cupboard and they have maybe a few drinks, and then what do you know, they end up in bed or something. Now, what should be the sentence? And mostly people are going to say, oh well, it's bad, you know, and I'd hate that to happen to my daughter, but maybe, I don't know, 6 months probation and a slap round the ear or something. In other words, they don't take in any way the same kind of approach that they would if you just asked that generalised question about sex offenders, as it were, because they've got something different in mind, of course, if you ask just about a sex offender. I think there are ways of if you like, taking down the heat, I suppose one might call it, in terms of victims' interest groups by saying, well, actually, the public is not as punitive when you actually ask them about specific instances. In fact, in the UK, it's been shown that in these specific examples, the public is less punitive even than judges, who are, of course, regarded by the legislature as irredeemably liberal and not punishing people enough, which is quite an irony, really, but there we are. Yeah.
You said that in the division of the law to first and second degree murder now, it sort of resembled the way things are in the United States.
I mean, it's not that, there are similarities, but obviously there's a lot of difference between state codes. I mean, premeditation is a big factor in first degree murder, whereas we don't have that really in English law, although it's there in French law, they have that there. But so, yeah, I mean, there are differences, but there's a sort of resonance there. Anyway, sorry, were you going to...
Well, yeah, it sounds like you have done sort of a survey of other countries and codes. And so I wondered, to what extent that's true and how you would classify that as a category.
Well, that's an interesting point. I mean, I think that the comparative analysis is really part of the job of the general principled reasoner, really, isn't it? And that's where, of course, scholars can perform useful work, because people can say, oh, well, this problem's going to arise, and you can say, well, yeah, but it arises in France, and that's the way they deal with it there, or something. It's actually not difficult to address. And so, but I would regard that kind of work as work that's done before you actually ask your question, if you like. So that helps you to try to formulate the right kinds of question for a jury. So, for example, you might, let's say you were consulting a jury, consulting the public about jury trial, and you're worried about whether, and this has been a worry, of course, that when the jury is deliberating on its own, there may be racist influence amongst the jury, and that will have an impact, and you won't know about that when they come back with the verdict. Now, of course, that makes an assumption, really, which is, of course, that juries are a group of ordinary lay people, some of whom may have prejudices of that kind. But of course, in France, for example, juries are comprised of 9 lay people and 3 judges. Now, that's something that not a lot of people know, as they say. And if you have a jury that's comprised in that way, you're much less likely, I would have thought, to have that kind of influence on the verdict. You're much more likely, I would have thought, to have a verdict that actually does what it's meant to do and analyses the facts and so on. So knowing that about French criminal procedure, you would then go to, if you were doing a survey on it, you would say, well, here we have this worry. Do you think it would be adequately solved by that kind of a solution, by having a professional person on the jury or something? So it just helps you to formulate get the public to think in certain kinds of ways. I mean, maybe they'll come and say, no, we don't trust judges. They're the last people you want on juries, right? Marcia.
Yeah, I'm curious about how it was decided which groups would be consulted, because I think if you ran something like this in the U.S., if you had the Dignity and Dying group consulted, you would have to have all the people who are very strongly opposed to...
Oh yeah, no, we had all those, just there wasn't room for them on slide.
Right. I was just wondering sort of...
the pro-choice, the pro-life alliance was one of the groups we consulted.
Right.
Yeah.
But probably not a group that would be in favor of, say, honor killings under certain circumstances, right? You probably wouldn't consult with them.
Well, I'm not sure there are groups in favour of them, because that would actually be a kind of inciting. They'd be almost a criminal organisation, wouldn't they? I guess.
Yeah, but let's say.
No, I know what you mean.
Highly sympathetic. And would want the provocation defense in particular to cover, say, those kinds of killings. I just was wondering, sort of, I was wondering how you decided. Was there disagreement about
who you should consult?
Yeah.
Not really, because it's not. The decisions are not taken in a very formal way. I mean, that's part of the problem with it, I suppose, is that one of the things you do is we do a lot of searching on the internet to find out who these groups are. And I don't think, I mean, obviously a criminal organisation, you're not going to start consulting them, but no, I think actually in our time we've consulted a very wide range of groups who have an input on law reform, not just, if you like, the respectable or well-known ones. I mean, that was particularly true, for example, when we were consulting on the extent to which consent should be a defence to assault, battery, crimes of that sort, because we had representation from groups who spend their whole time flogging each other with whips and other kinds of things, so not quite as respectable as some of these other groups. I mean, some of them were religious groups who believe in flagellation and things of that sort, and they said that their practices would be threatened potentially if consent was not a defence and so on. So I'm not saying they're not a respectable group, they probably are, but there was a willingness to consult actually with a very wide constituency, and so we're not, but you're right, I mean, the whole problem of interest group pluralism is about who's inside the lager and who stays outside. I mean, that is a big problem, I think. Yeah, sure.
No, I wasn't really raising it as a problem. I was just curious about how the process was used for it. I mean, another thing I was wondering, a possible group to consult would be relatives of convicted murderers and convicted manslayers.
Sure, sure.
And I don't know if they would be...
Yeah, they're certainly in. I mean, there's a group... I mean, partly it depends, Marcia, on whether these groups are sufficiently organised to have policy officers or somebody who can actually formulate a response, because otherwise you're not likely to get very much back from them. And a lot of these groups will have policy officers and people who can provide some kind of feedback, and that's really probably the only criterion, one way or another, as to whether they're worthy of consultation. I mean, we don't really look into it beyond that very much. But if they're sufficiently well organised for that, well then, yeah, they could certainly have an input. There's no reason why not.
Right. I have another question, but I'll save it until it's my turn. Well, you already spoke that.
Sorry, yeah.
So if you're moving towards consensus building, two scenarios come up in my mind. So what if you can't build a consensus to where your public poll shows 50% in favor of mitigating circumstances for killing in the heat of passion, for example. So I would assume you would consult scholars for that, and I'm kind of wondering what you would put in your final report. And then the second scenario would be, let's say people are overwhelmingly against something, but the scholars you consulted are overwhelmingly for something.
Yeah.
At what point does the popular opinion take the backseat to the experts?
Sure. Well, that's a good question, and I was a little bit resistant, Richard, when you were talking about consensus building, because although I mean, consensus building is the ideal scenario. I mean, in an ideal world, everyone would be in favour of what you propose, or whatever. I mean, that would just be great, wouldn't it? But of course, in the real world, that doesn't happen. But no, I'm not. There's no escaping the fact that ultimately the legislators, or whoever it may be, the people I was castigating earlier for behaving in this way, like the country squire. But ultimately, they're going to be taking the decisions, and so they have to decide to what extent they're going to balance what appears to be the public view and what appears to be an expert view. So if the public are divided on something, well then, one of the things we elect legislators to do, isn't it, is take the decision and live with the consequences, as it were. Please some people, because you can't please everyone all the time. You can only please some people some of the time. And so none of what I'm saying here is designed to in any way detract from the responsibility of the legislature. Indeed, I would say that even when the public is wholly in favour of something, there may be some instances where you have to resist, actually, and say, well, no, you can't have that for some reason or another. It might be breach of human rights, it might be some other criterion where you just have to say, well, no, we can't go down that particular road. So this is going to be quite a messy process, I think. So I think that nothing I'm saying is meant to detract in any way from the responsibility of the legislator. However, I'm trying to achieve something rather more modest, actually, which is to say that we have to try and just engage the public more, because there's so much evidence in the law field. It occurs in medical negligence cases, actually, that if actually you just consult people and ask what their views are, that often is enough for them to feel that they've been engaged. I mean, it risks the cynicism point, but there is actually a non-cynical way of actually genuinely engaging people, taking into account of their views, explaining why, if you're not going to do what they want, why you're not doing it, and then people will go away, if not, very unhappy, only slightly disgruntled, as it were. So, I mean, I think that is an important feature of what I'm saying. I mean, and we have those problems all the time at the Commission. Sometimes consultees will be in favour of something, and we'll just have to say, look, no, we can't do that for some reason, whatever it may be. And then we just have to live with that, really. So all I'm trying to do is just to create a more inclusive process, I suppose, rather than one that tries to make things decisive in that way. I think that's too risky. That puts too much burden on the question that you asked in the first place and all those other problems, which you don't really want to have to do. Great.
You have a consensus.
Great. Okay. Well, thank you very much once again. It's been fantastically enjoyable. Thank you for all your questions.